Hello, my name's Professor Brett Davies. I'm a barrister and solicitor at Legal Consolidated. This is a training course on helping people that have vulnerable children. So here we have a small article we've written just looking at the different issues that mum and dads are confronted when they have a child that needs more help than their other children. So some of the problems that can abound are the child is a spendthrift or can't handle money or is mentally unable to deal with those sorts of situations. What I'm going to do is I'm going to start building a three-generational testamentary trust will and just highlight some of the questions which you can answer in order to protect vulnerable children. So there are two types of wills. There is a three-generational testamentary trust mutual wills, that's from dad to mum, mum to dad, and there's a single will, which is just a person that's by themselves. So in my case, I'm leaving everything to my wife, she's leaving everything to me in the first instance, and after that, we're then going to leave everything to our children. One of our children needs special needs. So I'm going to press start building. Now there are a number of different trusts available in the three-generational testamentary trust wills. Now I can pick up data from an older client if I'd already built some other documents for this particular client, but in this instance it's the first time I've built a document for this person. Now I'm going to go to your full name goes there, your wife's name or spouse's name goes there, any alias names that you or your spouse may have, backup executor. So this is what we're going to start. Let's say you've got 3 children. One child is an alcoholic, is a spendthrift, but has got the ability to look after money if they got their heads together. Now, you would appoint 2 children at least, and you may consider appointing that 3rd child. And I'll tell you the disadvantages and advantages of appointing a vulnerable child as a 3rd executor. Firstly, the executors have to act unanimously, which means that the 3rd child, the vulnerable child, cannot make a decision without their siblings also agreeing to it. So it's like a blocking mechanism, but it means that that vulnerable child is still actively involved in looking after the money. Land tax on properties, doing tax returns, working out the investment strategy and things like that. So don't discount the vulnerable child being made a co-executor together with their brothers and sisters, or you could also appoint an uncle as well. So here, an example is a situation in this particular hint where your children are currently under 18 years of age, and therefore what this person's done is they've appointed Uncle Harry and Auntie Susan. There are many trusts available in your three-generational testamentary trust. There's a three-generation testamentary trust will that provides protection from capital gains tax, stamp duty, income tax. There's another type of trust is a superannuation testamentary trust, which reduces the 17 or 32% tax on your superannuation when it goes to adult children. There's a maintenance trust with children under 18. And there's also a disability trust where the children can never look after or unlikely to look after money at any age. And that's one of the trusts we're going to look at today. There's also a divorce protection trust. In case one of your children divorces someone, they will immediately try and get your money out of your will if you're dead. And this divorce protection trust reduces that opportunity. But let's have a look at the residuary beneficiaries. But firstly, age of majority. Now, it might be the case that you have 3 children. You would probably make the age of majority, say, 18. A lot of people make it 21, which means that all beneficiaries, so let's say one of your children dies and their inheritance goes to their children, their grandchildren, may only be 6 months old, they won't be able to touch the money till they're 21. So you will need an age of majority. And in this case, I'm going to make it 21 years of age. As far as to the disabled child, and there's a hint on that, so I'll just show you again. There's hints on all our websites. So here is the situation of of a child that is vulnerable. So you've got 8 children. One of your children suffers an injury and lacks mental capacity to handle money. You leave the general age of majority as 18 in this question. Later, you name this child, the vulnerable child. You make that particular age of majority for that particular child 99 years of age. And that will come up in a later question. How? How does that now work? If you dial up the age of majority, if you increase the age of majority from 18 or 21 or 25 to now 99 years of age, it means that your vulnerable child will never be able to get their hands on the money. But because of the extensive disability trusts and maintenance trusts which will be put in your will automatically, your executors will be able to drip feed the right amount of money to that child's carer, to that child potentially, or to an organisation that's protecting your child. Maybe they'll drip fed in a certain way which might be able to protect Centrelink benefits or government assistance the child's getting. So those executors can just drip feed the right amount of money, both income and capital, as they believe is the best interest of that vulnerable child. So what is some of the examples of a vulnerable child? Well, an alcoholic. We had a situation where there were 4 children. One child was an alcoholic. He was an alcoholic before he'd actually been 18 years of age, a very sad situation. By the time Mum and Dad had died, he was well in his 50s. He was not living a normal life. What happened was that the maintenance clause, the disability trust, allowed for the other remaining children to drip feed that vulnerable child the money that he needed. So they actually got him a house, they kept it in the name of a trust, and the child lived in the house. Something remarkable happened. They approached the alcoholic child. They got the child involved in some counselling, and they said, if we test you 10 times over the next 12 months and you have no alcohol in your blood, so you're basically alcohol free, we will hand over $100,000 in cash to you to look after. I thought it was quite remarkable. And more remarkably, the child, after 12 months, had been tested, had no alcohol in their blood at all, any time. So they put $100,000 in that child's bank account. About 7 years have now passed, and that child is still free of alcohol. So it does show that there's a lot of flexibility in what you can do and what you can't do to protect the child. And there's also similar situations where a child is drug affected. So these are situations which may right themselves, or it may be the case that the child is unable to look after wealth because of the drug affections for the rest of their life, in which case their siblings or their uncles and aunties as executors will merely look after the money for that child. Interesting thing about the other 3 examples, being a spendthrift, unable to look after money, and too trusting and liable to give money away to friends. And we've had that situation where people are of sound mind and just wonderful, loving people, but they are not able to understand that people will try and take money away from them, and do, in which case you don't give them the money. You hold it in the 99-year protective trust, and it's just drip fed to them at the right amount of time. But for that question, we're going to leave the age of majority at 21. And we're now going to go down to residuary beneficiaries. And this is where the action is. So in this case, we have 3 children. And I'm going to put the children in date order. So the oldest will go in first. And they'll get 33 1/3% each. Now in this case, Hannah is able to look after money, just an average 40-year-old person, and therefore they will get the money at whatever age that I die. Now, what I'm going to now do is I've pressed add another residuary beneficiary, and now have a second child. This child is a child that is vulnerable, and I've made the decision that I want, while the child will still get 1/3 of my estate after my wife and I die, don't forget to put the percentage sign in, they'll still get 1/3 of the estate, but they'll get the estate only at 99 years of age, which means they won't ever get the money. They won't ever get control of the money. It's their money. It's earmarked for them. No one else can use the money. It's for their benefit only. It can't be used for anyone else's benefit. But they're drip-fed the money as they need it, either directly to themselves or to institutions that are looking after them or carers that are looking after them. And that decision's by the remaining executors that you've named. In my case, in this situation, the two other children. That might be the case that one will get old and they'll then appoint someone else, maybe their own children, a grandchild of yours, that will take that position of trustee and continue to look after the money for the vulnerable Valerie. I have a third child, and that child will be an executor as well. So I've made those two children the executors, and I haven't, in this instance, I've decided not to make Valerie an executor of the estate. And that child gets 33 1/3%. But I leave the age blank because they're already old enough. Trying to get a Sydney address here. Let's try Double Bay. Double Bay, double pay. No, I'll leave it in Perth. Now I've got my 3 children, but the age of majority for Valerie is at 99 years of age. There it is there. Now let's have a look at the hints that deal with this particular issue. Firstly, your spouse gets everything first. So we're not, in this particular will, because this is a mutual will, a couple's will, or a mirror will. In this instance, when I die, everything goes to my wife. When she dies, everything goes to me. Only after both of us die will these 2 of the 3 children be executors, and this particular child won't be an executor, but be one of the 3 residuary beneficiaries getting a third each. So Valerie still gets a third, but she can't get the money, her hands on the money, until she reaches 99 years of age. Now, let's have a look at some of the hints here. So this is the issue of protecting vulnerable children. Now, we've dealt with the general age of majority, which was often 18, sometimes 21, rarely 25, sometimes 30. My father says you don't reach maturity till you're 50 years of age. Now that I'm 50, he thinks it's probably 60 before a man reaches maturity. So each to their own. But most people will nominate a standard age of majority of 18 or 21. But this particular question on residuary beneficiaries allows us to set a unique age of majority for one particular child, and that's Valerie. She's a special needs child, or she's potentially in the 40s or 50s at the moment, because she can't handle money, gives away money to friends, she's too immature. Now, if it's the case she's just too immature, but we think by the time she's 60 she might well be mature enough, we could change that age of majority to 60. You don't have to do it now, we can do it later. Remember, all the documents you build on our website, including our wills, can be amended free of charge as often as you want. So you might well just have a different view next year, email us a tax invoice, we'll send you a voucher, and you can redo the will. You can pull up the old data, change it as you see fit, and you can change your will as often as you want. Drug affected, suffers from a mental illness. Now we have a client. He suffers from bipolar, and he is a medical doctor, and practices as well as a medical doctor. But he does suffer bouts where he cannot handle money, and that situation, that's been put into a trust at that boy's request to his mum and dad. And his mum and dad have died, and that money's looked after for him, but it's all in property, and he is one of the 3 executors, and the assets are in his name, together with the other 2 executors. So it's not draconian. He is well aware of what mum and dad wanted to do, and he's very happy with it. And the money's protected. It's protected from bankruptcy as well, but bankruptcy trusts are also put into this will. So here we have an example of one particular child, we're going to increase the age of majority not to 99, but in this instance 35 years of age. This means the backup executors, your other two children in this case, one which may include the child, so they might have three. Remember, they have to act unanimously, executors, and also another name for executors is trustees. They have to act unanimously. They drip feed the child and their care or institution the money, the child, the needs. However, once that child reaches 35, because in this instance you didn't make the age of majority 99, you made it 35. Once that child reaches 35, they then take the money and do with it as they wish. So you would have hoped they'd reach maturity then. If you doubt they've reached maturity, you can make it 99. And if you're wrong, and if they are mature at 35, the other two executors can say, look, we no longer need these protective trusts anymore. We're going to release the money to you. And there's no stamp duty, capital gains tax, or income tax ramifications. There could be Centrelink issues, but there's no income tax or capital gains tax issues. Now, in this protective trust or maintenance trust for this child that is going to get it at 35, the money can only be used for that particular child. So while the child can't get their hands on the money, or not until they're 35, the money can only be used for their best interest. So the other siblings, the uncle, the aunt, or the other siblings cannot use the money except for the benefit of that particular vulnerable child. Now let's look at another situation, which is the 99-year clause, where it's highly likely that the child will never be able to look after money for whatever reason. And in this instance, we make the age of majority 99, and again, the backup executors merely drip feed the residuary beneficiaries or their carers money throughout their life. The challenged child, the vulnerable child, can be one of the backup executors, but again, that child can only act unanimously with their siblings, so they can't just take money by themselves. All three children, in this example, would need to agree with the release of the money. So with a maintenance trust, it's not it works to protect the vulnerable child. Now, if a child's under 18, then the age of majority is 18. It's the minimum age you can get assets out of a will. Then there's a protective trust for that child. If the child is unable to handle money, you can make the age of majority much higher to say 30 years of age. Or if the child can never look after money, you make it the full 99 years of age. And here it is, the inheritance for that particular vulnerable child, that particular beneficiary, that vulnerable child does not control the assets. The backup executors look after the inheritance on behalf of the challenged beneficiary. Now, if you didn't have a maintenance trust in place, the money may well go to the government to be looked after, which just, I think you want to, I don't know about you, but I'd rather trust my own family than the government to look after my children's money, particularly such as the public trustee or the state trustee in Victoria. They're government departments, they're government instrumentalities, and the last thing I'd want to do is tell the government what I'm doing with wealth, particularly with Centrelink benefits and things like that. You wonder if the government department acts best interests of the government, the state government of New South Wales or Victoria or Queensland or Western Australia or South Australia or ACT or Northern Territory or Tasmania. You wonder if they act in that state's best interest or they act in the child's best interest. And you also wonder who's looking after the money. Is it some 18-year-old kid at the public trustee or one of these trustee companies? So I think it's always better that the family look after wealth. But that's your own choice. Of course, the executors can always hand over the job to the public trustee, but I've never seen that happen. I mean, the fees the public trustee charge are, in my personal view, outrageous when there's no fees charged by the children. So, well, Professor Davies, how do they drip? You talk about drip feeding the money, but what does that mean? Well, the money can be used not just to buy toilet paper and a shop at Woolworths. It's not just to keep money to maintain your dead wife and your dead self's family home so the child can remain living in it, so they know their environment. It's not just that. The money may be used so the child can go for a holiday. The money may be used to buy a car so the child can be driven around. The child might want to have a bike, a very expensive bike. If you've got a large estate, then they're going to get a good quality bike. So this is not some draconian Charles Dickens type of poverty. This is just merely to protect the inheritance that you want to give to this vulnerable child, but so they don't just spend it willy-nilly. So here's some examples that we've been involved in. The money is spent for physical needs. So if the child's got a physical disability, you can spend money to help that child update your home so the child can move around in the home. If the child's blind or blind and of unsound mind. Accommodation, not just in your family home, but government as well. Support mechanisms, social support interaction, pay to have a carer come to look after the child. And also support hobbies. If the child loves a certain hobby, then you might well fly them. If the conference is in Madrid in Spain, the carer and yourself may decide to fly your child and the carer to Madrid to have that experience of that particular hobby. And health considerations, of course. Now, this is an extremely difficult issue, and it was a lot easier for me to do estate planning until I got married, until I had a child. And you know this as a parent, the issues of this is very emotional for everyone involved in this area, including the solicitors that prepare wills and what have you. It's only when you have a child that you have this animal instinct to protect that child where this becomes such a critical issue. And the hardest thing to do is when you're an 80-year-old person changing the nappy of your 60-year-old child. You wonder who's going to help that child when you and your spouse are no longer with them. This is an important process to protect the child. If you cut the child out, let's say you don't leave anything to that particular child, but you rely on the best wishes of the two remaining children, that in my view does not work. Because those two children are getting on with their own lives. They've got spouses, they get divorced, they go bankrupt, they do whatever they want to do. So in my personal view, it's better to leave, in this example of this will, 1/3, 1/3, 1/3, leave the disabled, leave the vulnerable child the 1/3, but put in that protective trust by dialing up, by increasing the age of majority, 99 years of age. That money is now locked and protected for that child. Now, if you need a hand, I would love you to ring me personally or any of our solicitors at Legal Consolidated, and we will help you, guide you through that process. So now we've got all the questions. See the green tick? So once I've got green ticks on all of these questions, I'll see lock and build. I press lock and build, put my credit card details in, and out come the document within a few seconds. But there's a couple of other questions I just want to look at as well, and that's the Guardianship Clause. Now, the Guardianship Clause, although I will say 18 years of age here, by law, a child, once they reach 16 years of age, believe it or not, can actually leave home without your permission. I don't know how they could afford it. We've got children still at 23 years of age living at home, but they can leave it at 16. But I've seen these maintenance clauses work for even 23 or 25-year-old children. So think about the guardianship clause. Obviously, if your child's 40 years of age, these have no value. They stop having value at 16 or 18 years of age. But if your child is under 18, I would really like you to consider putting a guardianship clause in the will. Now, finally, who can challenge your will? In all jurisdictions, in every state, your parents can challenge your will, but only if you're maintaining them. People you sleep with, like your spouse, wife, husband, mistress, gay partner, and you can have all three if you could afford to have all three. Bigamy is alive and well in Australia. Then the next group down are your children you adopt, and stepchildren in most states that you're maintaining. And the fourth group are grandchildren, but generally only if the parent is dead or the grandchild's living with you. So of great interest to this particular question is the vulnerable child. Because the vulnerable child is getting 1/3, but they're getting it on the terms that they can't touch and control the money themselves. And they therefore, on that basis, could challenge the will. In fact, if you were my child, one of 8, and I left 99% of everything I had to you, that my single child, you could still challenge for that final 1%. Now, I know you wouldn't win. I know that you wouldn't win, but you could still challenge for that final 1%. So whatever you do, a person can challenge a will, a child can challenge the will. And this vulnerable child, with the help of their friends that would like to get hands on the money, may well decide they want to challenge the will. In order to reduce the opportunity and make it hard and expensive for that to happen, you should consider putting a considered person clause in. So this, in this instance, in your will, you'll type in the name of that vulnerable child, and also in your spouse's will, you'd also put the name of the vulnerable child. That way, it makes them hard and more expensive to challenge the will. The wording is not mean or nasty. It's just the wording is, I've considered my obligations to ASDF, and I feel that I've given them enough. That's all it says. So it's not saying anything. That's not going through why they're vulnerable. That's not the issue there. This is a public document. Your will, once lodged at the probate office, becomes a public document. So the Channel 7 news crew, the Sydney Morning Herald, the Adelaide Times, anyone can get access to your will. So you can be very careful. With that vulnerable child, you can do a letter to explain why you've done this. My child did this, my child did that, in a loving, caring way. Now, then eventually you'll get to summary. Once you've got all your green ticks, I've only got 4 green ticks, but I'd go back and complete everything. Then you've got all your summary, which, if correct in the summary, will be correct in your document. And then you press lock and build, put your credit card details in. So I have now completed all my questions, and I said I've got green ticks on every single one of them, and there it is, lock and build. So, well, actually, before I press lock and build, I've just looked through my summary, make sure everything's correct, spelling's correct. I've got a percentage mark after 33 1/3, yes. I'm looking good. So I've got lock and build there, and I'm going to press lock and build. I'm going to put my credit card details in, and I can now access the document. So it's been built. It's also been emailed to me. Is that correct, Mark? Big email to me?
That is correct.
Excellent. So, but I can't wait. I'm too excited. So I'm going to get the will, and I can see all the wills I've done, and I'm just going to go to that particular will. And I've opened up my mutual will, and here it is. So the last will in 3 generational testamentary trusts and superannuation testamentary trusts. So you get a number of trusts in your will. Including the maintenance trusts, the child trusts, the bankruptcy trusts, the divorce protection trust, and the protective trusts. And while a child has not reached the age of majority, or not necessarily a child, but any beneficiary, so it could be your niece or nephew or friend or whoever it is, or partner, while they've not reached the age of majority, which is 99 years of age for that particular child, then the money's looked after for their education, advancement, support, benefit of that actual child. And there it is. That's the protection. That is the proper procedure in order to protect the child in need, in order to protect that vulnerable child. Now, please telephone me if you want to discuss any aspect of this training video, and stay close to your financial advisor and accountant who can help you also with this very important topic, particularly on the investments as you go through life, on the assets as well. This is a very difficult topic. I'm here to help, and together with all my lawyers, so please ring us anytime, and all the very best on finalising your estate planning and wills, powers of attorneys and medical powers of attorneys. Take care.